Okay guys, today we're going to talk about flood disclosure notices in New Jersey. So New Jersey came out with a new law March of 2024 that if you own property, you now need to have an addendum to your lease that is a flood risk disclosure. So if you own rental property in New Jersey, this applies for 3 units and up. This is something you need to do. Now before I get into this, we give a lot of great real estate tips on this channel, so please subscribe, click the bell. That way you'll get notified anytime a new topic like this comes up. It's much appreciated. And also, full disclosure, I'm not a realtor. I actually am a realtor, but I'm not an attorney, guys. We are a property management company that manages several hundred units in New Jersey, so we personally have to try to stay on top of stuff like this. So getting to the topic at hand here, flood risk disclosure. So what you need to do is you need to have an addendum either when you're placing a new tenant or when you're doing a lease renewal. Basically, the tenant needs to know at least once what the flood risks are at this property. And to do this properly, you have to go on the state website. They kind of give you a link to a FEMA map, and you have to type in the address of your property, and you have to search the flood zone that it's in. And every property in New Jersey is in some kind of flood zone. It just depends on if there's no risk or if it's in a 100-year floodplain or a 500-year floodplain. And each map, there's a 100-year map and a 500-year map. They both have different flood maps that you have to look at. So I know what I said sounds a little bit confusing. What I am going to do is I'm going to quickly go over flood risk disclosure with you that we personally send out on a lease renewal or with a new lease for 3 units and up, and I think that'll help you. But in a nutshell, you have to include this with your lease, because if you don't, guys, God forbid there's a flood or a freak storm, the tenant could have grounds to, seek restitution for any damages, especially if they don't have rental insurance. So, we're seeing that a little bit more in New Jersey, and it doesn't really matter what your politics are, but, the current governor, they're saying it's climate change, global warming, whatever you want to call it. It doesn't really matter. What matters is that we now have to have this in our lease. So make sure you are doing that, okay? So we're going to go over this right now, the flood disclosure notice, and then hopefully after this, you'll have a much better understanding of this.
Okay guys, so this is the flood risk notice that I was talking about, and this is something that we've gotten off the state website. This is just an example of one. So what you're going to have to do is you're going to have to look up the flood maps. Like I said, you can find that on the state website. And then what you'll do is a 100-year flood map and a 500-year flood map. You have to review the 100-year flood map first, and they have effective map and preliminary map. And based on what is input for your property, you'll check this off if it's in a 100-year flood plain, if it's on the effective map or the preliminary map. In this example, it wasn't on either, so we put no. Next, you'll check the 500-year flood map, and it's the same thing. They have effective maps and preliminary maps. See, on this property, it actually was on the effective map for the 500-year floodplain, and the same for the preliminary map. Finally, what the next question they'll ask you is, has this rental property ever experienced flood damage, water seepage, pooled water, whether at the premises or in the parking area? And you can put yes, no, or unknown. This owner put no. Right? So, and then the other 2 questions were basically not applicable. If you put yes, you're going to put how many times that event has occurred and then describe the event. So, like, something common is if there was damage during Hurricane Sandy, you might say, basement flooded during Hurricane Sandy. Then at the bottom, this is in bold, and it has to be in bold by law. This is basically lawyer jargon that comes from an attorney in New Jersey at the state level where they requested this. So hopefully this helps you guys. If you have any questions, feel free to DM me in the comments, and hope to see you in the next one.